Good morning, Mr. Pretorius. Good morning, everybody.
Morning, Chair.
Yes.
Chair, the legal team wishes to lead the evidence of Messrs. White and Deploy in the next few days. One or two of the implicated persons are Mr. and Mrs. Shabalala. Their counsel, Ms. Shazi, is here, wishes to bring an application to stay the evidence intended to be led. May she address you?
Yeah. Come and address me from here, Ms. Shazi.
Thank you, Chair.
Yes.
Chair, our application is simple and straightforward. We apologize, firstly, for not preparing a substantive application. We did not have enough time since receiving our notices. We received notices on, or my clients received their notices on the 9th of January, which was the Thursday before last.
I just want to confirm that you appear on behalf of Mr. and Mrs. Shabalala.
I do.
Just put their names on record.
It's Sipho Derek Shabalala and Beatrice Ndombenhle Shabalala.
Yes. Okay, and you're instructing attorneys?
SD Molloy and Associates
Yes, okay, all right. Thank
from
you.
Durban. As I was indicating, they received their notices on the 9th, and they found their way.
That is the Rule 33 notices.
The Rule 33 notices on the
Yes.
9th. The notices found their way to the instructing attorney that Saturday on the 11th, and I was instructed or briefed on Monday the 13th. We wrote to the commission the following day on Tuesday, and we only received a response back to indicate that we can come and bring this application on Friday, which is why we're here today.
You wrote on the 13th?
On the 14th,
On
we
the
wrote,
14th.
14th, we wrote to the
Yes.
commission,
Oh.
which was on Tuesday.
Yes.
We received the response on Friday, the
Oh,
17th.
okay.
And we could only come here today, and we were not able to prepare a substantive application. However,
Yes.
I was in the crunch time that we had, I was able to just prepare real written submissions on our application.
Yes.
Firstly, why we're here is we're not trying to stop the evidence from being heard.
Is there anything you want to hand up or
I have
not,
given it
not
to-
really? If you don't have it, it's fine. I'll just listen more carefully.
I have given it to my learned friends, and
Yes.
I have a copy for Chair.
Okay, all right.
This is sufficient. I have another one.
Yes. Thank you. Oh, there is more.
Thank you. Now, Chair, a little bit of a background. Our clients were arrested in 2010 pursuant to a criminal investigation, which the witness who's going to testify today will be testifying about. Now, subsequently, after their arrest, they were indicted in the Pietermaritzburg High Court. The trial, under the case number CC 14 of 12, the trial was supposed to start in 2010. It has yet to start. There have been currently, initially there were 21 accused. There's now 11. They've been whittled down to 11. Now, amongst the accused that are before court there's been a number of preliminary applications, interlocutory applications, permanent stay applications, a lot of starting and stopping, which has delayed the trial. It has been an untold frustration to my clients because they want their trial to start. Now, in trying to mitigate that prejudice that they are suffering because of the delay of the trial, our clients, we approached the Durban High Court and we brought an application in terms of Section 157 of the Criminal Procedure Act. Chair will be familiar with that, which is the separation of trials. On 17th of December last year, the Durban High Court granted that application, that the trial must be separated from the rest of the accused, because that trial there is not going to start anytime soon. There is still a pending permanent stay application that is still going to be brought. And once that is brought, there is going to be appeals upon appeals. Now, with the separation application having been granted, the way is open for my client's trial to start. Once the session starts in Durban.
So there are two categories of accused persons.
Yes.
There are those who say, we don't want this trial to take place anymore.
Yes.
For whatever reasons. Therefore, we have applied. So those are applying to the High Court for a permanent stay of prosecution. Your clients fall into a different category. Your client's attitude is, we want the trial.
Yes.
We want to be tried.
Yes.
And we want it as soon as possible.
As soon as possible. We don't want to get around it.
We are not part of those who say there should be no further trial.
No.
Yeah.
We don't want to get around it, we want to get through it.
Yes, yes.
But what we don't want is the delay.
Is the delay,
It seems now that it's not starting and there is no end in sight to these applications.
Yes, yes.
So what we approached the Durban court to do was we brought motion proceedings to order that our trials be separated so that it can start immediately.
Yes.
Now the way is open for us to do that.
Yes.
Now, as soon as the session starts, then we're going to set the matter down for trial. The state has indicated, it has been indicating throughout the permanent stay proceedings in the other applications that they are ready to start with the matter. So there will be no delay in bringing my clients to trial. Now, Mr. White, who's going to testify, whose evidence the commission seeks to lead, is the main witness in that trial. My clients allegedly are the nucleus of the charges against the rest of the accused. The corrupt act that supposedly was done, my clients are at the center of it. Now, if Mr. White testifies today, before he testifies in court, untold prejudice is going to happen, is going to occur to my clients. We are not stopping him from testifying. We're asking the commission to delay his testimony until he has testified in court. There's a reason why in the criminal proceedings, witnesses who have not yet testified are sent to sit outside and not hear the witness who's testifying at the time, because witnesses are known to color their evidence to suit the witness's evidence who's testified. It has prejudicial consequences for the accused. My clients are facing serious charges there, and sentencing provisions that follow the conviction are serious. Now, the commission is widely publicized. It has a vast audience, and unfortunately the commission cannot dictate who it reaches. The witnesses who are going to be testifying in that trial will be listening to this evidence, and they will know what is going to, and what, he's not only testifying, Mr. White is not only testifying about primary evidence, so to speak. He performed a forensic investigation into the corrupt activities or into the charges or allegations whatsoever. So his evidence is wide encompassing. He'll be covering the entire trial, him and Colonel Deploy. My clients want to participate. They don't want any allegations against them to remain unchallenged. They want to participate in these proceedings. But by them participating in these proceedings, it would require that we cross-examine Mr. White and Mr. Deploy, which means that our entire trial strategy is going to be laid bare in front of this commission before we start the trial, and in front of every other witness who's going to be listening and watching the commission. By the time we get to court to start the matter,
your voice is going lower and lower as you proceed.
I beg your pardon. By the time we get to court, at whatever time, even the loopholes that we would have, Mr. White's evidence, alleged loopholes that we would have sought to poke, he would be able to close them. This is one of the grounds for permanent stay of prosecution. Because if my clients, if this testimony is allowed to continue before it is heard in the criminal court, it is trial-related prejudice. the presiding officer who's going to hear this matter might be watching the commission. As much as presiding officers are able to divorce themselves from any impressions and all of that, but justice must be seen to be done. You cannot, for a fact, indicate that he's not influenced by what he would have had here. If this is allowed to continue, my client has grounds for a permanent stay application, which we are going to bring, and we will be citing the commission, unfortunately, as the basis for that application. I know that the chair does not want all of that. So we are just trying to avoid that. We're not saying, from what we've gleaned in the media and everywhere else, this commission is not going to end anytime soon.
Its lifespan goes up to the end of February.
This year or next year?
No, this year, next month.
This February.
Unless the court grants this commission an extension. We have applied to the High Court for the extension of its lifespan, but we don't take the attitude that the court will grant us the extension just because we have asked for it.
But I'm sure
the court will take into account everything.
Yes.
And we should not take anything for granted. I believe that the application that the commission has made has reasonable prospects of success, but I'm not the court.
I understand, not in this forum. But I'm sure Chair is hopeful that there will be an extension.
I am hopeful, but I'm not the court.
Now, if from what we've gleaned, from what we've seen, and the interest that the commission has had, it is unlikely that it will stop anytime soon if there's still evidence that needs to be led. What we're saying is, and now that we have the commission on our side to say that we need that matter set down for trial ASAP because there is evidence that is being held over at the commission for the trial to start. It's actually helping both ways. But if the commission hears this evidence before...
Well, Ms. Shazi, if we take your client's reasoning to its logical conclusion, what it would mean is that today you are here before me asking that we adjourn the hearing of the evidence of these witnesses because your clients must first have their criminal trial start and get completed, or at least maybe till these witnesses give evidence there.
Yes, they are the first two witnesses of the state, the first ones.
Yeah, and then if I agree to that, next week somebody else comes up and says, my clients are implicated by this witness you want to listen to, and their trial is coming up too. Please postpone the hearing of this witness's evidence. We postpone. That other week, another one comes. So where does that put the commission?
Chair, I understand, and I'm loath to stand here at the level of what happened last week.
We have issued, the commission has issued Rule 33 notices to, I believe, over the past 2 years to no less than 1,000 people.
But Chair,
and it continues to issue such notices to more people.
I understand, Chair, but how many of them have pending criminal trials?
Well, some are not pending. Well, some there are that are pending, who have not applied, who have not made this application, who have allowed witnesses to continue, but they have said, don't force us to give evidence because we are having a trial, there are issues that are being dealt with in regard to those. But they have not come to say, delay the hearing of the evidence of these witnesses who are implicating us. They've just said, we will, don't force us to come and put our version.
But we do not want to be forced to put the version. We want to put the version. Because as Chair is aware, there are adverse inferences. There are adverse inferences that are drawn either way, even in this commission. If a witness does not put a version, there's adverse inferences that are drawn there. In trial court, if witnesses do not put their version, there's adverse inferences that are drawn there.
But let's just deal with this thing quite quickly. Is your client's difficulty in having to disclose their version if they have to apply for leave to cross-examine these witnesses, or is their difficulty more than that?
Twofold.
Yeah.
One, as Chair has indicated, the difficulty is to have our trial strategy opened up here at the Commission, or revealed at the which we will have to do. And Chair knows how important it is that, cross-examination goes to the heart of the trial. That's one. Two, to have other witnesses who are going to testify in this trial hear this testimony before the trial commences. There's a reason why in court, witnesses are asked to sit outside before, when another witness is testifying. There's a reason for that.
Well, you see, we've got to strike a balance between public interest and the rights of individuals. There are many people who may be charged after this commission has finished its work, who will have witnesses in their trial who had been heard giving evidence. And the evidence that's been given and their statements become public documents once they have given evidence before the commission. Everybody has access to them. So that's inevitable. But it means that your client will know what the witness has said, and cross-examination that will be available to your clients during the trial will also look into that. So in other words, it's not a situation where everything can be 100% for your client. There may be some things that they don't like and would have preferred that by the time their trial happens, those things didn't happen. But when you have got to balance their interests as well as the interests of the public, some things may have to happen which they would prefer not to happen, because the matters that this commission is looking into are of immense public interest, and the commission has been hearing evidence for 1.5 years. It's 2 years after it was established. It needs to try and finish. In the court application that has been made for the extension of the commission's lifespan, it's been stated that we are asking for an extension up to the end of December. And if I grant the order that you are asking for, then I may as well forget about finishing this year. as you speak to me, you don't know when the trial will start. Even if you knew, we all know what happens with trials, particularly criminal trials, postponements and not finishing and all kinds of things. So it seems to me that I would need a lot of convincing to grant your application.
I'm trying.
Yeah, I know you're trying. Yes.
I'm trying. Now, I agree with Chair in saying that at the end of the commission, there may be people that will be charged, there may be recommendations, but that's a maybe. Those people may be charged. And in fact, what is going to happen is that the prosecution is going to use the evidence of this commission to tailor the charges of those people, to find out what has been said and all of this. So the evidence that's going to be led in this commission is very important. Now, with my client, it's not a matter of maybe. He is already charged. His charges are out there. He's already charged. He's already appearing in court. As much as Chair is saying we don't know when the trial will start, the state has already said that they're ready. What this needs is, in fact, that we approach the judge president of the High Court, who's going to give us a judge, and the matter starts. We're not asking, we are aware of the public interest, which is why we're not asking. But if you weigh that with the right to a fair trial of an accused who is facing a minimum sentence of 15 years, the only prejudice that is going to befall this commission if it delays this evidence is that it would have wasted half a day. There are other witnesses.
You assume you will be the only one?
So far, in 2 years, Chair, so far, as Chair has indicated, that people are not interested.
Well, you are the first one to say, please delay until my trial has been finalized.
No,
my client's trial has been finalized.
No, yes, so it's not that everyone else is going to do it. It's been 2 years that this commission is sitting and no one else
there are some who have already appeared in court a few times, like some who are connected with Busasa evidence that was led here.
And they've appeared consequent upon the evidence that was led here. They were not charged before that evidence was led here.
But does it make a difference? They could have the same complaint.
No, it does. It does make a difference, Chair, because the evidence that is going to be led by the state then, the state may not even lead the evidence that was led here. It will depend on the investigations that are still going to be done.
No, if they took the same position as you,
yes,
they would have come here and applied for exactly the same order that you are asking for when those witnesses who implicated them were going to come, because they too received 3 notices just like your clients.
Are we talking about witnesses that have already been charged or people that are expecting to be charged?
No, those who have appeared in court and who continue to appear in court.
After the evidence was led here at the commission?
Yes.
That's my argument, Chair.
No, I don't understand your argument, because I'm saying you said your clients received 3 notices.
Yes, they did.
And they were told that certain witnesses are going to come and give evidence that will implicate them.
Yes.
Those witnesses are witnesses that they believe will give evidence in their criminal trials.
They are going to give evidence.
Yeah, they are going to give evidence.
Yes.
And they have certain fears arising out of that.
Yes.
I'm saying with those people that I'm talking about, they received 3 notices. Those 3 notices said there are witnesses who are going to give evidence in the commission. They will implicate you.
Yes.
And those people didn't come to say delay, and then evidence was led, and then they were charged. They were arrested and charged. They didn't come and say stop. We continued. Yes,
Chair. I'm not sure why they did not, but maybe the difference is that their argument would have been these witnesses may give evidence against us.
Okay.
May. Mm-hmm. Our argument is that this witness is going to give evidence against us. He's the first witness in the trial. The forensic report is the basis of that trial. Yes. He is definitely going to give evidence. There's no maybe about it.
Okay.
So we are going to be prejudiced. It's not that there may be prejudice. We are. And the only prejudice that is going to befall the commission, as I was saying, is that maybe the commission is going to have to delay for a day. If we were given these notices timelessly, we were going to be able to deal with this beforehand so that we preserve time for the commission. The fairness of the trial is at the cornerstone of the criminal justice. And if my client's trial is ventilated in this commission before it is ventilated in the trial court, that is prejudice that cannot be undone. It cannot be undone. A witness who is cross-examined or who gives evidence and is cross-examined before he goes to the trial court and deal with the same witness and same cross-examination, obviously by the time he gets there, he will know what is awaiting him. And every other witness will know. This witness will testify.
And your submission is that that outweighs public interest?
It outweighs. If it would be one thing, Chair, if we were saying his evidence must not be heard at all. We're not saying that.
So you say it must be heard some time in the future, and you don't know when?
If Chair can give us or put us down to and nail us down to a date, we may be able to give you that date.
But it's not within your power.
We may be able to give you that date next week, because all that we need to do is to approach the Judge President to give us a judge and a date, which is something that we can do.
And that date might be October, November this year.
Well, from what we have ascertained, which is why we have been driving to say that my client's trial must start. It has delayed for 10 years. 10 years.
Yes.
So he's entitled to his day in court before he gets his day here at the commission.
Yes.
I think he's entitled to get his day there first. So if we approach, and we have the commission behind us to say we need to start that trial before the witnesses testify here. All we need to do is that this witness, who's the first witness, must testify, be cross-examined, and that's it. And then those two witnesses, and that's it. Not that the trial must end. For example, if the trial were allowed to run to its finality and my clients are acquitted, it would be something else for this witness who will come to testify here, but I'm not even going there. I'm only saying he must be allowed to testify there, and that's it. The moment he finishes testifying there, he can come to the commission and testify, and we'll come and cross-examine him here. And my clients will participate fully.
Do you need more than 3 minutes to finalize your submissions?
No.
You don't need more, okay. I give you 3 minutes to finish, but if you are done, it's fine.
Yes, that's basically our application, that it just be delayed for a little while. If we are nailed down to a date, we can give the commission that date, and the soonest date, it will be in, I don't know when the date is going to be, but it will be the soonest date.
Yeah, thank you. Thank you. Mr. Pretorius?
Thank you, Chair. We have prepared written submissions.
Yes.
And have attached some authorities, if I may hand that up. But before dealing with them, I would like to make 4 points. The first is that we have approached the matter from a point of view of principle and cited the relevant authorities for your convenience, Chair, because as you've already pointed out, what happens here may create a precedent in relation to some, if not all, the witnesses who have testified and who may yet testify. So it's important that the matter be dealt with at the level of principle from the legal team's point of view. The second point is that there's a degree of irony, not a degree of irony, there's an extreme irony in the approach of the applicants. The very separation that they ask for is a request to the court to deal with all the issues, in fact the central nucleus and all the issues in the criminal trial before the other accused are heard. It's precisely what they've asked for, they complain about in this matter. In other words, a canvassing of the issues in relation to accused still to come before the before the courts. The third point by way of introduction is there's an absurdity in the approach of the applicants. This commission is statutorily mandated to investigate criminal conduct. Criminal conduct which might have been contemplated for prosecution but delayed, as in this case. Criminal conduct which might yet result in criminal prosecution or which has already resulted in prosecution. You are then mandated, Chair, to make recommendations in regard to that criminal investigation or investigation into, amongst other things, criminal conduct. If you were somehow obliged in circumstances to delay the evidence until the conclusion of the criminal trial, the result is an absurdity. There's no purpose for the investigation at all. In short, Chair, this Commission has a job to do, and it must do it. The particular circumstances here are not circumstances which enjoy the protection of the law, and that is the principled approach that is highlighted. In fact, there is no compulsion here at all. The applicants have a choice. They can choose to cross-examine and deal with the consequences in putting a version in that cross-examination. Or they can choose to remain silent, absent a summons, which is not relevant here. That choice is recognized as a hard choice. It's a difficult choice. But its consequences are not protected by law. The only time the law steps in is where witnesses are compelled to testify in one proceeding when there is another parallel proceeding pending. And that is the nub of the allegation of the submissions that we wish to make before you. They're summarized on page 1 of the submissions, and I'll deal with the summary and then, for the sake of time and convenience, go briefly through the rest of the submissions, but these submissions are complete in themselves. The first point is that, in essence, what the two witnesses are saying, that in these circumstances, not only do they have a right to remain silent, but also they have a right to prevent evidence being given in the course of the inquiry. That goes much further than the other circumstances dealt with in the cases. But where an accused person is implicated in parallel civil and criminal proceedings in the commission and in a future criminal trial, a stay of the civil proceedings or these proceedings will only be granted where there's an element of compulsion. In other words, only where the accused or the potential accused has no choice but must testify. That is not the case here. There is a choice, and that choice is as far as it goes for them. They are not under any compulsion to provide any self-incriminating evidence. You will know, Chair, that the furthest that the law goes, the Act and the regulations, is to provide some degree of protection against persons against self-incrimination. That certainly doesn't go so far as to protect the Shabalalas or the applicants in this case. Instead, they face a choice. Now, this choice has been recognized in a number of cases. They may challenge the witness's evidence by testifying and cross-examining, or they remain silent. There's a third choice. They may apply to cross-examine and put their version after the criminal trial. That's a third via media that they may adopt. Such rights as exist in law, including the right to self-incrimination, do not protect the applicants in this case. Such interest as they have alleged to protect trial strategy, for example, are not interests that are legally protected. Those interests, such as they are, to reveal the strategy that they may adopt in cross-examination, to put their version in a prior proceeding, must be weighed, as you've pointed out, Chair, against the statutory duty of the Commission to investigate and hear evidence of criminal activity. It's inherent in the statutory mandate of this Commission that it will hear evidence of criminal activity before a criminal trial. Any other approach is simply nonsensical. As I've pointed out, if evidence of criminal activity had to be stayed for whatever reason, including the reasons here, pending the conclusion of a criminal trial, there would be no need for the Commission at all. Chair,
Well, I got the impression during Ms. Chazi's address that she recognized that her clients at this stage have not been compelled and they might never be compelled to testify in regard to issues or matters which could incriminate them before the trial is held. So they are the ones who may choose not to challenge the evidence of these witnesses, at least at this stage. I seem to have got the impression that she was relying more now on saying, well, there are other witnesses who will be called at trial who will be listening to these witnesses, and they might adjust their evidence. I don't know if you want to say anything about that.
Well, Chair, that's inherent in the duty of this commission. Potential criminal activity, allegations of criminal activity are widely canvassed. Not only the allegations, but the responses to the allegations. It goes to the central point of what is the mandate of this commission. If this commission were to delay the hearing of evidence because witnesses in a future criminal trial may listen to the result is absurd. It just cannot ever be that the work of this commission must be curtailed because people may listen to what is going on here and may adjust their evidence accordingly in later criminal proceedings. In fact, it is inherent in the notion of a public inquiry which may lead to criminal proceedings that the issues are fully canvassed. In fact, the history of this commission and its continuing work will be based not only on allegations being made, but allegations being fully dealt with from all angles, including contrary versions.
Yes.
So it's inevitable that these will be heard. And it's contemplated that this be so in giving the commission that mandate.
Yes.
If I may...
do you need more than 3 minutes to finalize your submissions?
Point taken, Chair. I just want to refer you, Chair, to paragraph 45. That's the best one. Which is one of the cases which recognizes the involvement of a person, including a potential accused, in two fora, whether it be a disciplinary inquiry, whether it be a statutory inquiry, whether it be a commission of inquiry. And the position of the courts is to say, where you're not being compelled, where you might have an argument, and the protection there is just limited, the evidence can't be used later, you have a choice. Your choice may not be a pleasant one. Your choice may be to put your version and suffer the consequences of putting your version. Or it may be to remain silent and face the consequences of remaining silent. But that is your choice, and you must face the consequences of your choice. Simply put, says the court, this is the Supreme Court of Appeal, when a party is required to appear in different fora, each of which has jurisdiction in respect of the subject matter, the manner in which that party deals with the process in each forum is a matter of choice, which holds particular consequences attendant on the choice so made. The difficulty in the choice, which is recognized, and the difficulty of the consequences of making a choice one way or the other, have been recognized by the courts. But they have said, absent compulsion, that is simply how it must be. Thank you, Chair.
Ms. Shazi?
Unfortunately, Chair, I won't be able to respond point by point to what my learned friend said. I was not, as much as I supplied them with my written arguments, I was not given their copy.
Oh, is that so?
Yes, when the lady here asked if I should be furnished with a copy, the gentleman said no, so I'm not sure why. But I don't have a copy of their submission, so I'm not sure, I can't follow, I couldn't follow. I'm not sure why I was not allowed to have a copy of their submissions.
Yes. No.
But be it as it may, for some reason, it was kept to themselves.
Well, I can...
Sorry, Chair, if I may intervene, that was a complete misunderstanding. It
Yes.
was the intention to hand the copy when we
Yes.
addressed you, and I apologize
Yes,
that
I
it
would
wasn't
imagine
done.
it must have been a misunderstanding. Well, maybe, do you want me to stand them to adjourn and give you a chance at least to read? I haven't read it myself, to read it and...
Yes, I would love to. I would have loved to do that initially when they had
so that when you
attempted
respond,
to give it to me.
So that when you respond, at least we have had a chance to,
Yes,
to
thank you,
read
Chair.
it. We are at 9 minutes to 11. It's... well, I see the first part is about 9, 10 pages. I think the rest is just authorities. Shall I give you, 15 minutes?
That would be fine.
But that
Can
would
I
be
have
fine.
the authorities? Thank you.
Okay, all right. We will adjourn for 15 minutes, so we'll resume at 11:05.
Thank you.
We adjourn.
Chair,
didn't
before the
expect to see
reply,
you. Yes.
may I just use a few seconds of the 3 minutes that I was granted to draw your attention just to 4 paragraphs, 4 sections, where the authorities deal succinctly with the issues before you.
Yeah.
It's paragraph 22. These are of our legal submissions.
Yeah.
Paragraph 22.
Yes.
Paragraph 28. Paragraph 32 and 33. And paragraph 45.
Yeah. Okay. Thank you. Ms. Shazi.
Thank you, Chair.
Yes.
I'm going to be very short. Chair was correct. Our gripe is not so much so as that we are being denied the right to remain silent. Our gripe is that we're being denied the right to be presumed innocent. In that criminal allegations or evidence against my clients is going to be ventilated in this public forum other than a court of law, a very, very public forum. Each case must be decided on its own merit. I understand what my learned friend is saying, that in parallel proceedings, you have civil proceedings and you have criminal proceedings, and in most of the case law that is being, that was handed up, it's mostly disciplinary hearings where people were testifying in disciplinary hearings. This case is different. We're not talking about evidence that is being led in a room with one stenographer and 2 officials and 1 person hearing that evidence. We're talking about evidence that is led before 50 million people. I'm not sure how many people are in this country. 50 million people who are watching. And one of those people is the presiding officer who's going to hear this matter. That presiding officer
is that your biggest worry?
One of my biggest worries. One of my biggest worries. In fact, if Chair turns into one of the precedents that were handed up, Law Society of Cape of Good Hope versus Randall, you see there on page 441, paragraph 15. The judge there says, Judge of Appeal says, I turn now to the general principle as it applies where there are both criminal and civil proceedings pending which are based on the same facts. This is what's happening here. The usual practice is to stay the civil proceedings until the criminal proceedings have been adjudicated upon if the accused person can show that he or she might be prejudiced if the criminal proceedings should the civil proceeding be heard first. That is why we're here. We're here to say that we will be prejudiced if the civil proceedings are heard first before the criminal proceedings.
How will you be prejudiced? Simply because these 2 witnesses give evidence here before the criminal trial starts. I see benefit to you because you are going to watch these witnesses, and you can come and sit here, watch these witnesses give evidence here. These witnesses will be questioned by the legal team of the commission.
Who does not represent my clients.
Yes, these witnesses are not the legal team's clients. The legal team is not taking anybody's side. They want to establish what the truth is. The rules of the commission make that clear, that a member of the legal team is entitled to question a witness to establish the truth. So you will be watching, your clients will be watching, and see how these witnesses answer questions. By the time that they testify in the criminal trial, your clients have already watched and listened to them as they give evidence, and they get asked questions and they answer. I see a lot of benefit for an accused person who gets that chance. The first benefit an accused gets is when they get the statement of a witness who will get to give evidence, so they know in advance this is what this witness will say. Now, here, they'll get the further advantage that the witnesses will testify in the open. Not only that, they'll be questioned about their evidence. So your clients get a chance to even be more prepared for when these witnesses testify in the criminal trial.
I take the chair's point. Yes, the witnesses will be asked questions for clarity. They will not be cross-examined.
Well, you say for clarity. I say the rules say to establish the truth.
Will that be tantamount to cross-examination?
Well, I don't know whether it amounts to that, but it says to establish the truth.
I take the chair's point, but
But your clients
yes.
have a right to apply to me for leave to cross-examine these witnesses. Of course, if they do that, they've got to put up their version, and I think that's where your client's problem, or part of the problem.
What part of the
lies,
problem?
yeah.
Yes, part of the problem. And Chair is correct in saying that we can sit here and we can listen to the evidence. My clients will be listening to the evidence. Our problem is that everyone else will be listening to the evidence. There will not be a reason why a presiding judge does not have foresight of the evidence that is going to be led. There is not going to be a reason why witnesses are not even, the prosecution policy is that you cannot even consult with two witnesses at the same time. You cannot, because it is very, very important that witnesses become impartial. It is important that witnesses testify independently, in the independent recollection of what happened. This is not going to happen if this witness is allowed to testify. There will be no point to it, but the courts are very rigorous in making sure that the rights of the accused when it comes to witnesses who are testifying being independent is not infringed upon, because it goes to the heart of the right to be presumed innocent. If there was no consequence and serious dire prejudice to the accused, then every witness would be allowed to sit in court and hear the evidence. Here, the commission is a draw card. People are drawn into listening to this evidence, to the evidence of the commission. And everybody who will be testifying in their trial. The part of the problem is the part of remaining silent and my clients having to come here and cross-examine. But that's a choice. They don't have a choice.
But do you realize that there may be many persons who will be charged after the commission has finished its evidence, in respect of whose trial there may be witnesses who will have had access to the records of the commission and the statements, public statements that have been given here. So people will get to know who said what, including witnesses who will testify. They will get to know.
I'm very alive to that,
Yeah.
Chair, and appreciate that. I'll take 3 more minutes. I'm very alive to that and appreciate that. My gripe with that is that that may happen or may not happen. That's why we are here. That's why those people...
hang on.
Yes.
In regard to persons who get charged,
Yes.
once they get charged,
Yes.
after the commission has finished its work, they are in the same position as your client, in the sense that although the witnesses have given evidence, they will have access. Other witnesses can have access and could actually have had listened to evidence without knowing that necessarily they will be called.
Yes, I agree.
But they get called,
Yes.
and they did hear the evidence.
Yes. What my point to the Chair, as I say, it's a maybe, that after this commission has concluded, the state will have, by the state I mean the prosecution, they will have a chance to do further investigations. They may not even lead evidence that is being led at this commission. It is very possible that their investigation may have different legs. They can come up with an entirely different set of charges, might be stemming from the evidence, but they may not lead evidence of the witnesses that have testified here. So there's a lot of maybe and presuppositions, and I take from what the chair is saying. I'm here to say it will happen. It is going to happen. The prejudice is real. There's no likelihood of it. It's
the will and
going to
maybe
happen.
are on different things.
I beg your pardon, Chair?
The will and the maybe are on different things. When I talk about will happen, it's certain things. But when you talk about whatever prejudice you say your client would suffer,
Yes.
is the same prejudice that anybody will suffer if they are accused, they are charged,
Yes.
after the commission has finished its work. 2, a witness is called who has listened to the evidence of certain witnesses.
Yes.
You said certain witnesses might adjust their evidence. So, because they have had access or they have heard what these witnesses say.
Yes.
So in regard to those people that I'm talking about, the same thing also could happen when somebody is charged.
I hear you.
In your case, your client is going to trial,
Yes.
and some witness, you say, may adjust their evidence.
Yes.
So I've put the mays together and the will together
Yes.
now.
What I'm complaining about is that the maze at the end of the commission, people may not be charged. It will depend what the state intends on doing. People may not be charged. Witnesses may not be called. The prejudice will befall if they are charged.
Yeah, but
so there
do
may
you
not
agree
be any
that
prejudice.
those who are charged will be in the same position as
If-
your client?
if they're
Those
charged.
who will be charged, do you agree that that category would be in the same position as
So
your
we
client?
know that there are people that will be charged.
No. If that category happens,
Yes,
do you agree that they would be in the same position as your client?
I do if the state uses the same evidence. If the state
Yeah.
uses the same evidence.
Yeah.
That's where I am.
Yeah.
If the state, there are so many ifs and buts and presuppositions, they may not even be prejudiced. It may just end up being just my clients.
I'm making you take long. You said you would be short.
It may just, yes. It may
Yes.
just be my client. There's an if, it may not happen. And in fact, the state may just not do it to guard against this complaint, because this complaint may happen at a later trial. They may then decide to do their own investigation and get their fresh evidence. It may be premised upon the work of the commission, but to guard against this complaint, because it will be raised. They may not do it, because they are alive to it. But that will not be, for my client, the ship would have sailed. It would have gone. The SCA recognized that it's a general principle that if you can prove prejudice, then the civil proceedings must stay until the criminal proceedings have been. It's a general principle until the criminal proceedings.
I don't
have
want us
been
to take too long, but I don't understand the authorities to which Mr. Pretorius referred to be saying that they place reliance on compulsion, as I understand them.
Yes, in the
And
same.
here there is no compulsion.
That is when it comes to right to remain silent.
Yes.
But that's not the only prejudice that you can show. You can show other prejudice. I've quoted on paragraph 15 where it says it is a general principle. You can show prejudice. You cannot only show prejudice because your right to remain silent has been infringed. There's other prejudice that you can show, which is what we're trying to do, to show prejudice that our right to a fair trial is going to be infringed. The right to be presumed innocent to a fair trial will be infringed if a trial is ventilated before it is done in the criminal.
Do you need more than 3 minutes now? Are you done?
I am done.
Are you sure?
Yes.
Okay, all right.
Thank you, Chair.
Just
Just one
yes.
point. One point. The statutory obligations of the Commission do not trump constitutional rights of an accused person. They cannot. If that were to be allowed, it would be a sad state of affairs. I'm
Thank
done
you.
now.
You are done now. Okay, all right. I'm going to dismiss the application. If the applicants really require me to give reasons, they will request them, and then they will be given. The application is dismissed.
Thank you, Chair.
Are we ready to continue?
Chair, we are ready to continue.
Yes.
Ms. Wenzel
Yes.
will deal with the next witness.
Yes.
5 minutes.
Or should we, maybe we should
There are
take...
a number of files that need to be,
Yes.
we need to clear our own mess.
Okay,
So,
we'll
Chair,
take...
could we take 5 minutes?
We'll take an adjournment that will take the place of the tea break. On my watch, it's 22 minutes past. We will resume at 22.
Thank you, Chair.
22:12. We adjourn. Yes.
Good morning, Judge.
Good morning.
Judge, as earlier alluded to in chambers, I record that I am here representing MEC Peggy Nkonyeni. Judge, she's the MEC for Human Settlements and Public Works. Judge, we've received the notice quite late, but we have received the notice nonetheless. And Judge, for the record, she reserves the right to file an affidavit or bring an application to cross-examine the witness if it really becomes necessary after the witness has testified. Judge, I'm also on Saturday, I was forwarded the notice for General Ngubeni, the former provincial commissioner,
Yes.
in relation to the witness who's also present.
Yes.
I have duly forwarded to her,
Okay.
and she has advised me to furnish the same reservation.
Yes.
After the witness testifies,
Yes.
she'll then decide on her alternatives that are available to her in
Yes.
terms of the rules.
Okay. No, that's fine.
Thank you, Judge.
Thank you very much. Ms. Wenzel, I don't know whether it's you or anybody who
Yes,
put that in there.
yes,
I
Chair.
think it should be separate.
Yes,
It's more convenient that way.
yes,
I hope the witnesses one is also separate.
yes, it is. And Chair, I took the liberty of doing it for that very purpose because when we're referring to so many annexures, I thought it might be helpful for all of us to have the affidavit
Well,
itself separate.
You see, if you want it to be here, don't put it in a file cover. Just put the statement. But once you put it in a file cover, it's a file on its own, and it's quite awkward for it to be here.
Yes.
What
Chair,
do you want to do
what
with
I
it?
was proposing was that the statement would be marked Exhibit RR4, and that each of the next files which contain annexures would be marked RR4A, B, C, D. If that was a convenient way for you.
What will be A, B, C, D?
All the other files in front of you, you'll see there are 4 files.
I've got
I
only
think
2
you've got
files in
one.
front of me.
You've got an A, there should be a B, and a C,
Mm-hmm.
and a D file.
Are these all annexures to Mr. White's statement?
Yes, they are.
Yeah, they can be A, B, C, up to whatever. But what I'm talking about is whether you want his statement, his affidavit, to be part of A.
I think it would be more convenient if it wasn't part of A, it is separate, and it's just on its own called RR4. It could be RR4 sub 1, but it could just be RR4, and then the exhibits will be files A, B, C, and D, whichever is convenient.
Yeah, we'll have it separate. And then maybe you may have to put it into a smaller leverage file.
Chair, I'll arrange for that to
yeah.
be done for you over the lunch adjournment.
Yes. Okay. Do you want me to admit these?
I would like you to admit these exhibits.
The affidavit of Mr. Trevor Sean White is admitted and will be marked Exhibit RR4. Then there are 4 liver arch files which contain various annexures to that affidavit, and the one file will be marked RR4A, another one RR4B, another one RR4C, and the last one RR4D.
Thank you, Chair. Chair, also for the record, before we commence, just in response to Mr. Makaklau's statement that he only received the notices on Saturday, Chair, I have shown him the printout prepared by the Secretariat, which shows that these notices were sent to both of his clients on the 20th of December 2019, and both of these were delivered. He indicated to me that perhaps there's a problem with their email server their side, but from the Commission side, those notices were timeously sent.
Yes, okay.
Thank you.
Thank you. Yes. Please administer the oath or affirmation to the witness.
Please state your full names for the record.
Trevor Sean White.
Do you have any objection to taking the prescribed oath?
I do not.
Do you consider the oath to be binding on your conscience?
I do.
Do you swear that the evidence you'll give will be the truth, the whole truth and nothing but the truth? If so, please raise your right hand and say, so help me God.
So help me God.
Thank you. Yes, you may proceed.
Thank you, Chair. Mr. White, have you submitted an affidavit to the Commission?
I have.
And is the affidavit without the annexures referred to in Exhibit RR4 in front of you?
It is, Chair.
Can I refer you to page 57 of that affidavit? In fact, sorry, 56 of that affidavit. Is that your signature?
That is correct, Chair.
And you confirm that the averments in the affidavit are true and correct?
That is correct, Chair.
Thank you. Mr. White, where are you currently employed and what is your position in that company?
Chair, I'm a partner and director of PricewaterhouseCoopers, and I work in the Forensic Investigations Department.
And what are your qualifications?
Chair, I have a Bachelor of Commerce degree, which I obtained in 1987, a postgraduate diploma in accountancy, which I obtained in 1989. I was admitted as a member of the South African Institute of Chartered Accountants in 1992, and I was also admitted as a member of the Association of Certified Fraud Examiners in 1998.
And what is your experience as a forensic auditor?
Chair, I've been involved in conducting forensic investigations since 1996. I've conducted what must be more than 1,000 investigations during that time. I've testified in court on investigations conducted, of which I would say 90% are criminal matters, and I've testified more than 50 times in South African courts and the Lesotho High Court.
Mr. White, could you tell the Chair how you became involved in the investigation into the contracts awarded by the South African Police Services in KwaZulu-Natal to the businessman Mr. Toshin Pandey?
Chair, PricewaterhouseCoopers was on the police panel of forensic accountants. It comes out every 3 years. We'd submitted it and we were on that panel. There was then a request to provide a quotation in terms of that panel, which we did, and we were subsequently appointed to assist the police with undertaking the forensic investigation in support of case 781 as it was known. This was the case relating to the allegations of irregularities and corruption relating to procurement by the South African Police Services in KwaZulu-Natal relating to, amongst others, the procurement relating to the World Cup in 2010.
Thank you. Pursuant to your mandate, did you prepare a report?
I did, Chair. The report, which I issued on the 24th of November 2014, was some 400 pages long. It's attached to this affidavit, and attached to that report is 20 lever arch files of supporting documentation, which is cross-referenced to that report, Chair.
And if you have regard to Annexure TSW1, it's Volume A, Exhibit A. Does that entire file comprise of your report?
You'll have to be consistent and use the correct exhibit name. Are you referring to exhibit RR4A?
RR4A, yes.
Yeah.
Thank you.
Okay, what page?
Page 59.
Chair, that is correct. That report that starts at page 59 of RR4A, the front page of that report is signed by myself, and my signature also appears at the last page of that report, which is the last page in that bundle at page 510.
Thank you.
And if you have regard to page 115,
One 115.
yes. Is this a list of all the annexes to your report? The documentary evidence.
Chair, that is a list of documents that were provided to PricewaterhouseCoopers to assist us with doing the analysis of the procurement and the flow of funds between the various entities. Only the relevant pages therein were attached that I actually referred to my report or attached to the report, but that's a total list of documents that the police provided, and one can see from page 118 there was 43,700 documents, pages of documentation.
So the information in the columns at pages 115 to 118, does it reflect a recordal of all documents that were given to you by the police?
That's correct, Chair.
Okay.
And Mr. White, on page 114, paragraph 9.001, you deal with the sources of information used to compile this report. Could you please tell the Chair what those sources were?
Chair, they were all documents provided to PricewaterhouseCoopers by the investigating officer and his team, and the source of the documents were documents that came from the supply chain management department of the police, including their policy. There was bank statements that had been subpoenaed, as well as images of various computers which the police cybercrime unit had made and had provided to us to undertake the investigation.
And finally, Mr. White, on page 112, paragraph 4.002, in the second line, you say, the scope of my work was limited to a review of the documentary evidence made available to me and inquiries undertaken to address issues identified in the execution of the investigation undertaken. Is that correct?
That is correct, Chair.
Thank you. You also state in paragraph 6 on page 113, it's 6.001, that This report focuses on documentary evidence provided by the SAPS, which documents have been acquired from the SAPS SCM Division, Operational Response Services, Gold Coast Trading, Unite Mzansi Trading, Kasief Traders, BravoSat 25cc, Valotone 21cc, and the residents of Pandey, in addition to the bank accounts of the aforementioned entities. Is that correct?
That is correct, Chair.
Could you please tell the Chair what was the nature of the investigation? What was it about?
Chair, this investigation related to various allegations relating to the procurement of goods and services by the South African Police Services in KwaZulu-Natal in the lead up to the World Cup in 2010. The overall allegation was that entities linked to Mr. Toshon Pandey, when I say linked, entities in his wife's name or his mother's name or his brother-in-law's name, were used to provide quotes where no third party was providing a quote, and that this enabled them to quote significantly above market-related prices, thereby making significant profits that it would not be in the normal course of business, and that policemen within the supply chain management department, being Colonel Madhu and Captain Arainpasad, assisted them in assuring that they received this beneficial treatment, and over the same period, Mr. Pandey's entities were purchasing gifts for them that they were enabling them to circumvent the supply chain management procedures of the police. So effectively, the report that I prepared summarizes the procurement process, shows how it was circumvented, how Colonel Madhu and Captain Arainpasad helped with that process. We then show the benefits that they received and how they received it. And then at the same time, show the benefit that the former Provincial Commissioner Ngobeni, the procurement of a birthday party for her husband, was paid for by Mr. Pandey at the same time that she was instructing the police officers in KZN to stop this investigation.
Thank you. How much was paid to Mr. Pandey and his related entities?
Chair, it was approximately 47 million rand. And that, Chair, was in a period from November 2009 to August of 2010. So some 10 months.
And from your investigations, were you able to assess what profit margins were being charged by Mr. Pandey's entities?
Chair, on average, they were billing approximately 3 times the price they were procuring the goods for, where it was physical goods. And when I talk about goods, it could be anything from a generator to a garment to sunscreen to a notice board to a Fenta trailer. They literally supplied anything the police required at the time. The accommodation, in some instances, they billed for accommodation that was never provided. And in other instances, they billed just more than twice what it was costing them, they billed the police for.
Mr. White, I'd like to refer you to paragraph 16 on page 6 of your report. Could you please tell the Chair who were the suspects in this investigation?
Chair, there were 12 suspects, some of which were natural persons. The first one being Mr. Pandey. He effectively was the main person involved. He was the person that in most instances we could trace the payments to the various police officials involved in procurement directly to his instructions. The police officials involved were Colonel Naveen Madhu. He was the head of acquisitions for the South African Police in KZN. Chair, he also approved payments relating to the payment to Mr. Pandey's entities, as well as dealing with the sourcing of accommodation, particularly for the World Cup. And Chair, when I refer to accommodation for the World Cup, this is accommodation for the police members that are coming from outside of the Durban area that needed to be on duty during the World Cup. Captain Ashwin Narayanprasad, he was also in the procurement department, and he certified that goods had been received. He was also instrumental in summarizing the 3 quotes to give the impression that a procurement process independently sourcing quotes from the market had been prepared. But in all instances where Mr. Pandey's entities got paid, they were the other 2 entities related to Mr. Pandey in one way or another. There's then Lieutenant General Ngubeni, who was the Provincial Commissioner at the time, who, based on affidavits that were given me to consider relating to the date and the time of the birthday party that was paid for on her behalf, she was in the month leading up to that birthday party giving instructions to Brigadier Kemp and General Boyson to stop the investigation. Then from a national perspective, there was Major General R.S. Pillay. He was involved in signing off documents relating to the accommodation for the World Cup, and he signed off motivations just before the accommodation was required to be booked, saying that it was urgent, when, if one looks back to the various meetings that had taken place for some 8 or 10 months before, they knew at least that long before the accommodation would be required. And the police procurement procedures do not allow a lack of planning as a basis to justify an urgent or emergency procurement that then doesn't follow the procurement process. The 6th person is Ms. Pravisha Pandey, that is Mr. Toshon Pandey's wife. There's then Ms. Arvenda Pandey, which is Mr. Pandey's mother. And then there are the entities that are involved. There's Gold Coast Trading CC, of which Mr. Pandey is the sole member. That was the entity that provided the accommodation, both for the World Cup as well as for other deployments of police officers in KZN. Then Unite Mzansi Trading and Project CC. This is an entity that Mr. Pandey is the sole member of. This entity was used to quote against Valotone 21cc, which was owned by his wife, and Bravostat 25cc, which was owned by Mr. Pandey's mother. And then Kasif Traders CC was owned by Savesh Ishwar Kumar, which is Mr. Pandey's brother-in-law. He's married to Mr. Pandey's sister.
The one origin, Unite Mzansi, that's how it's registered, because it looks like they confused where the S should be and where the Z should be. They must have intended Mzansi.
I agree, Chair.
Yeah, but that's how it's registered.
That's correct, Chair.
Okay, all right.
Thank you, Chair. Now, Mr. White, in your report, you deal extensively with when and how Mr. Pandey's wife, mother, and brother-in-law came to own the companies you referred to, Valotone, Bravostat, and Kasif Traders. And you also deal with how these companies were reflected on the supplier database. This is dealt with by you on from pages 119 to 130.
I see that the list of the suspects appears at page 6 of Mr. White's affidavit, paragraph 16.
Yes, it does.
It will help if as we go along, we know whereabout in the affidavit we are. Of course, you will refer to the other exhibits, but it helps if one knows exactly where we are.
Chair, I actually did say it was page 6 on paragraph 16, but I know I think I did say that, but I will make sure that I tell you where we are in the affidavit.
Yes, no, that's fine. Just mentioning
you.
paragraph numbers of the statement as we go along will
you.
help me to see where we are.
Yes. Chair, I won't follow in the course of giving this evidence the affidavit exactly, but I will
That's
certainly
fine.
show you where we are.
Yeah.
Um,
So you refer to exhibit R4A, that's right? What
Yes.
page number?
We were referring to, it's dealt with essentially from pages 119 to 130, but I'm
Okay.
now going to look at page 134.
Okay. Continue.
Mr. White, without me reading what is contained in your report with regard to this, could you perhaps, with regard to the enlarged timeline, which is Annexure TSW25, referred to in Exhibit RRD, right at the end, explain to the Chair what happened with regard to the ownership of that company?
Maybe before he does so, let's establish how he went about the investigation. Did it involve interviewing witnesses? Was it just document-based? Mr. White, do you want to just explain that to me? How did you go about with your investigation?
So, Chair, our appointment was to assist the investigating team that was allocated this investigation by the police. They provided us with all the documentation. They then, the individual investigating officers went and obtained statements from the various people where they needed a supporting statement around whether a service was provided, whether the supplier had 20 rooms if the accommodation that was paid for was 20 rooms, and in some instances the supplier only had 10 rooms. So if the people weren't sharing, the accommodation couldn't have been provided. So the police went and obtained those statements and then provided us, when I say us, I mean PwC, with copies of those statements, and we would have input into the questions that would be asked of those witnesses and information that we required to enable me to make the conclusions I made in my report. So PwC and the staff assisting me from PwC didn't specifically interview the witnesses that were that provided statements that are in the criminal docket. Chair, just in that regard, there are literally hundreds of statements, because every time there was a person identified that did something, investigating police officers went and obtained statements from those people.
Is the position that after you had looked at some statements or at any statements, if you wanted clarification, you would indicate to the relevant police official to say, we want this information from this witness, or would you write directly to the witness and obtain the information, or pick the phone and ask them, or how did you go about that?
Chair, we worked very closely with the police officers, and that would be done in discussions. And then Colonel van Lochenberg, who headed up he was the main investigating officer, he would then instruct the other policemen working for him to go and take further statements. So in some instances, there would be a statement in the docket, and then there would be an addendum to that statement which had further information around specific issues that I required clarity on before I could finalize my report.
Okay, so your team was providing assistance to the investigation conducted by the police.
Correct, Chair.
That's right. Okay, thank you.
Thank you. Mr. White, if we can go to page 134 of your report. You there say in paragraph 10.051, with regard to Volotone 21C, no, with regard to Bravostat, who you've said was Mr. Pandey's mother's company, you say this: the certificate issued by the Registrar of Companies and Closed Corporations dated the 28th of June 2010 reflects that, as at the 28th of June 2010, the only member for Bravostat 25cc was our vendor Pandey. However, the Experian report extracted on this entity reveals that she resigned as a member thereof the same date she became a member, namely 9 November 2009, at which date Pandey became the sole member of this entity. I have also established from documents provided by CIPC that a vendor Pandey became a member of Bravosat 25cc on the 26th of October 2009 and resigned on the 9th of November 2009, although the CIPC was only informed of her resignation on the 12th of April 2011. I can therefore conclude from the above-mentioned documents that our vendor Pandey was initially the only member for this entity and who was recorded as the only member thereof as at the 28th of June 2010, a year after the registration on the SAPS supplier database. However, subsequent to the aforementioned date, the CIPC was informed of her resignation as the only member of Bravostat 25cc, which date is recorded as the 9th of November, although the CIPC was only informed of her resignation on the 12th of April. The aforementioned documents concur with each other. Yes.
Ms. Wenzel, you can't
Yes.
read for so long. Here is the witness. This is his report. He knows his report.
Yes.
Ask him questions that will elicit the information that you want him to place before me.
Yes. I wanted, with reference to those paragraphs, if you could please refer to Annexure TSW 25.
Before that, Mr. White, Ms. Wenzel, don't forget the question you wanted to ask. Your report, I see there are writings on the margin, on the side, F2/2-3. What do those signify? What do they represent?
Sorry, Chair, I should have explained that at the beginning. And I referred to it at the bottom of each of those pages. Those references in those columns are references to the supporting documents that were in the 20 lever arch files that are attached to that report.
Yes.
So anywhere where I refer to information in the report, a reader of the report can go to the source document where I got that information from.
Yes. Okay. And would they also be helpful now in regard to the other exhibits that have been admitted, or they would have been helpful at the time for your own investigation? If I want to see the source for anything you write there, those sources would be here, or some would be here, others won't be here.
Chair, none of those documents are attached to this affidavit that I've prepared.
Yes.
But I have provided them in electronic form to the Commission, so they're all available.
Okay.
It's just all the annexures I referred to in the reports before the Commission.
Yeah.
There's some 50 lever arch files of documents.
Yes. But what you mean is they can be found if necessary. Yeah.
Chair, the Commission has them.
Has got them in electronic form.
Yes, Chair.
Okay, thank you.
Thank you, Chair. Mr. White, with reference to Annexure TSW 25, Exhibit RR4D, it's at page 1986.
You are speaking away from the
Sorry,
microphone.
it's at page 1986. Could you please explain what transpired with regard to Bravostat? I'm sorry, is that suitable if it's the whole document? Yes. Thank you.
Chair, that annexure is just, it was included in the report that's being referred to.
That annexure is on what page in Exhibit RR4A?
Chair, it's in RR4D.
It is in RR4D. Okay.
It's 1986, Chair.
Yes. Okay, continue.
Chair, that is just a representation on a timeline showing some anomalies that relate to the registration of the companies relating to Mr. Pandey's wife and his mother. So the
Just speak
document,
to them.
the document that is currently on the screen, which is at page 1986 in RR4D, just sets out the date the entity was initially registered, being the 9th of November 2009. The fact that, and I'll deal with the change at a later date, and the fact that at that date, Mr. Pandey's wife was the member. A bank account in the middle of that page was opened on the 18th of November 2009. Mr. Pandey's wife was the sole signatory. And on the 30th of November, it was registered on the police supplier database. When it was registered on the police supplier database, it was registered as an entity owned by Provisha Pandey. What then happened was almost...
I'm sorry. It was when it was registered in the police database, it was registered as an entity owned by who?
Provisha Pandey.
That is Mr. Pandey's wife.
That's correct, Chair.
Okay.
Chair, just
So-
what I'm trying to show there is that from the date this entity was first registered, on the
Yes.
9th of November,
Yeah.
before the end of that month, being the 30th of November, this entity had opened a bank account and had registered on the police supplier database. From what...
I'm sorry. Did you say that before it was registered, a bank account had been opened?
No, no, Chair, shortly after it was registered. So if we look at page 1986 and we start at the left in that timeline, it was registered on with...
I'm sorry, hang on one second. You say page
1986.
Is that the page, well, 1986, okay.
Correct, Chair.
Okay, now I see. Okay, all right.
So, Chair, in the bundles there's an A4 document with a copy in A3 as well, so that it's easier to read.
Yes. Okay, continue.
So, Chair, if we start on the left, the entity was first registered on the 9th of November 2009.
Yes.
We skip the other date and we move to the middle of the page. They opened a bank account on the 18th of November,
Yes.
and they were then registered on the police supplier database on the 30th of November.
Yes.
So this is a brand new entity. It's just been opened.
Yes.
From what my investigation showed, they did no work for anybody else, only for the police. However, some 2 years later, on the 17th of August 2009, on the right-hand side, there was an instruction sent to SABC, the entity that controls the registration of closed corporations, recording that Mr. Pandey's wife had resigned on the 9th of November 2009, being this very day she was appointed, and replacing him as the sole member. Chair,
Well, I'm sorry, Mr. White. I've read your statement, so I have a certain understanding, which I want to make sure I check whether it's correct. I thought, based on my reading of your statement and what you said earlier on, I thought there is a point to be emphasized that you want to emphasize with regard to who was registered as the member of the CC when. Is it convenient to deal with that point first, or
Chair.
is it more convenient to deal with other things and come back to it later?
Chair, I can deal with it now.
Yes.
So the point is that when this entity registered on the police supply database, to try and give the impression, is my view, that it was independent of Mr. Toshon Panda,
Yes.
the sole member was registered as his wife.
Yes.
However, at a later point, once this investigation started, they went and backdated her involvement to remove her as a member of that closed corporation. But what they couldn't change was the date the bank account was opened and who the sole signatory was, and they couldn't change the record on the police supply database where it was recorded as being his wife's entity.
Yes, okay. Let's deal with it this way as I read the annexure. On the 9th of November 2009, that's when this entity gets registered. Is that right?
Correct, Chair?
And at that stage, the founding statement of the closed corporation, and the closed corporation we're talking about is Valotone, is that right?
Correct, Chair?
Valotone CC. Ms. Previsha Pandey, previously Samachif, is the sole member of the CC.
Correct, Chair.
And then you have in the next column something relating to the same date, 9 November 2009, and you say on the same day, Ms. Previsha Pandey resigns as sole member of Valotone 21CC. Is that right?
Correct, Chair.
But that resignation, is it effected in the Intellectual Property Office or not?
Chair, it's only
At that stage?
not at that stage.
Not at that stage.
It's only reflected in that office on the 17th of August 2011.
Okay, the date which is right at the end of that page.
Correct, Chair.
So, but is it backdated?
Correct,
Is
Chair.
the resignation backdated?
Correct, Chair.
So, so this organization, Valotone 21CC, gets registered on the 9th of November 2009, and its owner or sole member is reflected as Ms. Pravisha Pandey, Mr. Pandey's wife. And then on the 18th of November 2009, a bank account is opened at Absa, and the sole signatory to the account is Previsha Pandey, Mr. Pandey's wife, in regard to this entity. And on the 30th of November 2009, this entity is registered in the SABC supplier database. So as at the time when it is registered in the database of the SABC on the 30th of November 2009, as far as the records at the Intellectual Property Office are concerned, Ms. Previsha Pandey is the sole member of the CC.
Correct.
Is that right? And when that registration at SABC is made in the database of the SABC in regard to this entity, she is reflected as the sole member of this CC.
Correct, Chair.
And then you say, on the 17th of August 2011, that is now close to 2 years later from when it was registered. At that time, a letter is then submitted to the Intellectual Property Office to say that she had resigned, not to say she was resigning as at that time. Is that right?
Correct, Chair, that she had resigned on the 9th of November 2009.
And that is what is submitted to the Intellectual Property Office, a letter that is dated 9th December 2009, or what is, or is it the text of the letter or email of resignation that tells that office that this resignation is with effect from 9/11/2009?
Chair, I can't recall the exact form of it, but it was that it was effective the 9th of November 2009.
That's however it was put, that was the effect.
Correct, Chair.
The person who put it, Miss Pandey, intended the Intellectual Property Office to take her resignation to have been with effect from the day on which the entity was registered with them.
Correct, Chair. So if one has an inquiry on this entity with Intellectual Properties Office now, they will show that she resigned on the 9th of November 2009.
Yes, yes. Of course, in all probability, legally, the resignation should only be with effect from the date when the Intellectual Office maybe got the letter. I'm not sure, but in any event, she intended that the resignation should be taken to have been with effect from the day on which the entity was registered.
Correct, Chair.
Okay, thank you. I just wanted to understand that point, because I thought in your statement you make that point quite clearly. But there may be other points you want to make in regard to this.
Chair, just at the same time, when one considered Bravostat, which is his mother's company, the same thing happened. The dates are slightly different as relates to the resignation date. But the opening of the bank account, the registration on the police supply database is exactly the same. And also, the resignation is backdated by close to 2 years. So it appears that these entities were registered with people related to Mr. Toshon Pandey, but not himself personally, applied to be on the police suppliers database. Those entities were then used to provide quotes competitively against each other, competitively used quite loosely. But after they had stopped doing work for the police and this investigation had started, Mr. Pandey then went, or these two ladies went and backdated their resignation to say they were never the members of these entities.
Yes. And yet, throughout the period, as far as the Intellectual Property Office is concerned, and therefore as far as the public is concerned, and as far as the SAPS were concerned, it was in the case of Valotone 21CC, Ms. Previsha Pandey, who was recognized as the sole member of that.
Correct.
Yeah, okay.
And Mr. White, was anyone in procurement told that Volotone, that Ms. Previsha Pandey was no longer a member of Volotone between the 9th of November 2009 and the 17th of August 2011?
Not based on the records I've seen, Chair.
Did you ask the police to inquire from Ms. Previsha Pandey why this was done?
Chair, they were the suspects, so as far as I'm aware, they were not interviewed and warning statements hadn't been taken up to the date when there was a decision not to prosecute the accused.
So at this stage we don't know what they say, what they have to say about this very strange way of doing things.
We don't, Chair.
Yes, okay. Ms. Wenzel, have the investigators checked with them? How do they explain this?
No, Chair. You will see that this statement from Mr. White was obtained in the middle of December. Investigators all then went on leave. And as far as I'm aware, I don't know if they have been approached as yet to determine what their version is as to why this occurred.
Okay.
Thank you, Chair. Could you please explain what transpired with regard to Bravostat with reference to Annexure TSW 26, Exhibit RR4D? It's on page 998.
Sorry, Chair, it's 1988.
198.
Yes,
sorry.
1988.
Chair, that's just a timeline that's very similar to the one I've just referred to for Valetone. The only difference is the date the entity was registered. In this instance is now the 26th of October 2009, and the date there was an amendment to the founding statement. And the other difference, obviously, is this one relates to Mr. Pandey's mother, whereas the previous one related to his wife. Otherwise, what they did with his wife's entity, they did effectively the same thing with the entity that his mother was a member of.
I saw in regard to the previous CC that we just dealt with that from the beginning your documents reflect or refer to an amended founding statement even at the time of registration. That gives the impression that there had been a founding statement which was subsequently amended, but that is that the position?
That is correct, Chair. From what I could determine, these entities were effectively shelf closed corporations, so businesses that are in the business of registering companies or closed corporations.
Yes, okay.
They register a whole lot and then they just...
Oh,
so
okay,
an
okay.
employee of the organization that originally registered this
Yes.
was the first member. So
Okay.
that's why
Okay.
the very first one is an amendment.
It's an amendment to replace whoever may have been the sole member when this was in a shelf, so to speak.
That's correct,
And
Chair.
then to reflect the new and sole member with effect from the date of registration of the amended statement.
Correct, Chair.
Yeah. Okay. So that the registration, the registration would not be the first registration of the CC, because the CC would have been registered before it was put into a shelf, so
Correct.
to speak. It's the registration of the amendment, which then reflects the new sole member. That's what it means.
Correct, Chair.
Okay, all right. Please continue.
Thank you. Now, with regard to Kasif Trading, which you said was owned by Mr. Pandey's brother-in-law, was the same amendments made to the founding statement?
No, Chair. So he continued to be the member from the documents that I've seen.
And then if you have regard to Annexure TSW 27 on page 1990,
Are you done with the one for Bravo Start? I thought you had asked him to talk to that one.
I beg your pardon, I thought he'd completed. Is there anything further you would like to say as to that one?
No, Chair.
Because I think as and when you get to the others, you can then deal with whatever issue relating to amendments, if there's issue.
Yes.
But it's better that once we have got to one, let's finish with that one.
Yes.
Yeah.
Thank you.
Chair, relating to Bravo Stat,
Yeah.
effectively the modus operandi was exactly the same.
As in the...
As in Valotone, which...
Yes.
So they did the same thing. They registered on the same date. They then backdated it. So the portion that related to the registering with the police and opening the bank account was exactly the same days.
Yes, well, let's just get this sort of out. On the 26th of October 2009, the founding statement of the CC was amended, and it then reflected from that date, that is for Bravo Start 25CC, it reflected Avenda Pandey as the sole member of the CC, and you said Mrs. Avenda Pandey was Mr. Pandey's mother?
Correct, Chair.
Is that correct? And that, and then on the 18th of November 2009, a bank account was opened at ABSA in regard to Bravo Start CC, and on the 30th October 2009, Bravo Start CC was, Bravo Start 25CC was registered in the database or supplier database of SAPS, and on the 12th of April 2011, Ms. Avenda Pandey submitted, whether it was a letter or a document, to the Intellectual Property Office indicating that she had resigned from as a member of Bravo Start 25CC with effect from 26/10/2009. Is that correct? Have I summarized this part correctly?
That is correct, Chair. Just with one correction, just for the record, you said it was registered on the police supply database on the 30th of October. It's actually the 30th of November.
Yes, thank you, 30th of November 2009. So it was exactly the same method as we have had in regard to the other CC.
Correct, Chair. And again, just to highlight that entity was registered shortly or transferred into Mr. Pandey's mother's name shortly before they registered on the police supply database, and they then did work for the police or were paid for services provided to the police for the next 6 or 8 months. So again, newly registered entity onto the police supply database within a month, and then they immediately proceeded to receive significant orders and were used to quote against each other to give the impression that there was competitive pricing obtained by the police.
Okay.
And Mr. White, when was Gold Coast Trading and the other corporation of which Mr. Pandey was a member, when were they registered?
Were they registered on the same day? Otherwise, we should go do the same exercise one by one, unless they are registered on the same day.
Mr. White, the point is, were they companies of which he had been a member of a long time, or was it similar in that?
Chair, it wasn't exactly the same timelines. I can't recall off the top of my head, but it wasn't exactly the same.
Yes. Had they been there for quite some time, or, as you recall,
Chair,
not too long?
Unite Mzansi had not been there for long. I'm just trying to, if any of them had been there for longer, it would have been Gold Coast, because that was his main entity that he operated. I'm just trying to. So they had only shortly before this, around the same time, registered on the police supply database.
Is it all the others or only specific ones?
Well, Chair, there's those two
many.
entities. There's then Unite Mzansi, which is Mr. Pandey's entity, and then Gold Coast Trading, which is his entity.
Yeah. Okay, well, Ms. Wenzel, you must just tell the witness exactly what you want him to look at, so maybe during lunch, the lunch break,
Yes.
he can have a look, and then you can ask him
Yes,
the details later.
Yes, I'll do that. I asked you earlier whether this same modus operandi that was used with regard to Bravostat and Valitone was employed with regard to Kasiev Traders, which was owned by Mr. Pandey's brother-in-law.
Chair, he did not resign from the company and transfer it into Mr. Pandey's name like the wife and brother had done. Sorry, wife and mother had done.
And from the timelines, you've referred to annexures TSW 25 and 26. What inferences can you draw from this?
Chair, it appears that these two entities were registered with the sole purpose of obtaining work from the South African Police Services. They were registered, bank account opened on the police supply database, and within a month receiving significant orders. Chair, and the reason I say that is when one looks at the procurement documentation within the police records, those two entities, together with Unite Mzansi, Mr. Pandey's entity, were used to cover quote effectively against each other, so that the police were procuring goods at significantly inflated prices. So, and from the records that I was provided that were seized from their business premises by the police, they did not appear to do work for any other entity. So it appeared that this was a specific planned event, form these entities, and then use them to effectively manipulate the police procurement process with the assistance, because it can never work if you don't have a person within the procurement department assisting. So with the assistance of Colonel Madu and Captain Narain Prasad.
Mr. White, which of these entities was in the main used to provide accommodation, and which entities were in the main used to provide goods?
Chief, Gold Coast was the entity used to provide accommodation to the police, and the other entities effectively quoted against each other for the supply of any other specific goods that were provided to the police. So the other entities didn't provide accommodation.
And with regard to the goods supplied, so the chair can get an idea of the nature of the goods, I'd like to refer you to Annexure TSW1. It's in Exhibit RR4A at page 268.
What page?
268, Chair.
Did you say RR4A?
Yes.
And page 268.
Yes.
Okay.
Chair, maybe just to place it into context before I explain what's in that table, is the South African Police Services at the time, and we're now talking 2009, 2010, they had a supply chain management user manual, And in that manual, it stated that all procurement must be fair, equitable, transparent, competitive, and cost-effective. As the Chair would know, those are the same requirements as set out in Section 217(1) of the Constitution. It also set out levels on which what was required by way of competitive quotes or tenders, depending on the level of authority. If it was above 200,000 Rand, there was a requirement to go out to open public tender. If it was less than 200,000 Rand, 3 quotes could be obtained, they would be compared, and the cheapest entity would be appointed. In terms of Colonel Madu's level of authority, he could approve, he was the final signatory on the 3-quote process, so he could approve that the cheapest of the 3 quotes could be appointed to provide the services.
That is now for items that were less than 200,000.
Correct, Chair.
Okay.
So, Chair, if one looks then at page 268 of RR4A, that table is a summary of procurement authority submissions. Chair, now, a procurement authority submission is a document that's prepared summarizing the 3 quotes that have been received. So the names are inserted, the prices, and then based on the prices, a rating is done in terms of a scoring, and then there's a recommendation that the cheapest one be appointed, and then there's an approval. Chair, the process of preparing the document and verifying it to the supporting documents was undertaken by Captain Narain Prasad. And then the approval...
I'm sorry. Captain Narain Prasad, was he Colonel
Madu's
supervisor?
Junior, Chair.
Junior, okay. My understanding of the ranks in the police and the army is terrible.
So, Chair, the captain is junior to the colonel.
Oh, okay.
So Mr. Narain, or Captain Narain Prasad, is junior to Colonel Madu. So he prepared the document, summarized it, and then Colonel Madu approved it, or authorized it.
Okay.
So he signed it off and said the order can be placed,
Yes.
and then the procurement process follows. Captain Narain Prasad then confirms that the goods and services were received, and then they get paid for.
Okay.
Now, Chair, that table at page 268 is a summary of 23 procurement authority submissions that were seized by the police from the Supply Chain Management Department of the police. So it was seized by Colonel van Lochenberg and his colleagues. And what I've done is I've summarized those in that table. Chair, just one can see if one looks, so there's 23 lines. The second column relates to the date. Those are all dated the 6th of May 2010 or the 5th of May 2010. So all 23 of those submissions and approvals were done on this within 2 days of each other.
Yes. So would those dates reflect the date on which the quotes were received, or the dates when some decision was made?
That would be the date they were approved.
They were approved.
Correct.
Okay, all right. And in this case, the person to approve was Colonel Madu. Okay, all right.
And the preparation had been done by Captain Narain Prasad.
In each case?
In each case, Chair.
Yes.
So, Chair, just to put in context, those are two of the individuals that Mr. Pandey was purchasing gifts and benefits for around the same time.
Yes. Okay.
Chair, then just to highlight the type of items under the goods required column that were being purchased. So line 1.
Yes, well, maybe. Yes, okay, go ahead.
So just without going through all the lines, there's digital cameras, sleeping bags, floodlights, notice boards, sunscreen, ration packs, Garmins, angle iron, fender trailers, beds. So, Chair, it's almost anything you could possibly think of.
Yes, yes.
Is supplied, and this was just a summary of some of the items. I mean, there were blankets, there were all sorts of things in other ones.
Yes.
Chair, then just to the three entities that provided quotes according to those documents, it's in the middle of that page. It's Kasif Traders, Unite Mzansi, and Velatone.
Well, they've got Mzansi correct here, but that's not how it's registered.
Chair, I think when I was...
The correct version is the incorrect version.
No, Chair, I think it was wrong in the previous reference in my affidavit, Chair.
Oh, it's not how it was registered.
Yeah, Chair, I think I actually had a mistake
Oh,
previously.
okay, this is the correct
Chair.
one. Okay, no, that's why.
So, Chair, those are the... And if one looks at the prices, they are fairly similar to each other, but we then have in the column third from the right, the company approved, and we can see the first 5 were awarded to Kasif Traders, the next 5 to Unite Mzansi, and then the balance to Velatone. Chair, there's in...
On the screen, you have got this on what we are looking at. If you can put it on the screen, I think that might be helpful for people to see. But basically, the first one at the top, SAPS required digital cameras, I think 2 of them, and Kasiev Traders, Unite Mzansi, and Velatone put in quotes. Kasiev put in a quote for 37,000, Unite Mzansi 38,500, Velatone 39,500, and these were all entities whose sole members were linked to Mr. Pandey.
Correct, Chair.
And then this document reflects that in regard to digital cameras, Kasiev Traders quote for 37,000 was then approved.
Correct, Chair.
And then one can go down right through all of them. The same thing happened, and they actually, these 3 entities, Kasiev Traders, Unite Mzansi, and Velatone, they all sent quotes in regard to 23 items required by SAPS as stipulated here.
Correct, Chair.
And sometimes the one was approved, sometimes it was another one. All of them, at one stage or another, there was approval. Some, Kasiev got some approvals for some codes, Unite Mzansi got some approvals for some codes, and Velatone also got some approvals. So they all shared this business.
Correct, Chair. And what I will show later is that some of that money they received, they then subsequently paid up to Gold Coast, which was Mr. Pandey's entity.
And in Gold Coast, he was the only sole member.
Correct, Chair.
Yes.
So while he was using these entities to win the work
Yes.
and receive payment from the police.
He was the ultimate beneficiary.
Correct, Chair.
Yes.
Chair, but maybe...
Did you say in some of them or in all of them?
No, in some of them, Chair, because...
Some of them, yeah, okay.
Because obviously these entities would have to pay for the goods they bought. So all the money can't go back to Gold Coast.
Yes, okay.
But Chair, maybe just to come back to use one as an example to show the prices that they received for the specific goods. If I could refer to line 8 and line 10. So line 8 and line 10, the goods required are ration pack. Chair, so on the same day, the 5th of May 2010,
Yes.
ration packs were ordered And Chair, it's not summarized here, but there were 500 packs each of those orders.
Yes.
It was a total order of 1,000, but 2 orders of 500.
Yes.
Chair, if one looks at that, the cheapest price was provided by Unite Mzansi at 142,500.
Yes.
Chair, it's my opinion that those orders were split into 2, because if a total price of 285,000 had been the price that they were going to order the goods at,
Yes.
there would have been a requirement to go out to tender,
Yeah.
because it's above the 200,000,
Yes.
and Colonel Madu couldn't approve it.
Yes.
So on the same day, they split it. The police pay 285,000 rand, if one adds the 2 together. We found that in the records that were seized from Mr. Pandey's entities, that the original cost of these goods was 93,201 rand.
So in effect, either Mr. Pandey or one of his entities, the entities, or one or more of them, effectively paid 92,000 rand, you said?
93,000.
93,000.
Correct.
But the SAPS paid more than 200,000 for the same thing.
Paid 285,000.
Yeah.
And as a result, this entity being Unite Mzansi, made a profit of 191,000 rand. So they charged the police more than 3 times the price
Yes.
that the police could have bought it for.
Yes.
And Chair, that's fairly consistent
Yes.
across the board for all the suppliers, regardless of what they were supplying.
In regard to these entities.
The goods are marked up
Yeah.
to that extent.
Yeah.
And Chair, I can make that conclusion because the original supplier invoice was found in Unite Mzansi or Valatone's records by the police,
Yes.
and then the investigating officers went and obtained statements from those suppliers confirming they'd supplied the goods, the
Yes.
price, how they were paid, which entity paid them,
Yes.
etc.
Yes.
And just in this instance, the supplier invoice is for 1,000 goods. It was then split into 2 of 500 when it was supplied to the police on the same day. So they knew they were receiving an order for 1,000
Yes.
because they bought 1,000 from their
Yes.
supplier.
Yes.
Chair, I believe the only inference that can be drawn is it was done on purpose to
Yes.
keep it below the procurement level that Colonel Madu could approve.
In order to make sure that it doesn't go out on tender.
Correct, Chair.
Yes. Okay.
Thank you.
You don't have the total, I'm sorry, Ms. Frenzel, you don't have the total of the amount at page 268 when you put all of these together to be able to say maybe just on these 23 items they got like 10 million, but if the police had actually just gone out and bought these themselves, maybe they would have paid only 3 million.
Chair, what I did do is I summarized that at the end of the report, and I cover it later in my affidavit.
Okay.
And by way of example, just in round numbers, the goods that were bought for 4 million rand, round, they supplied them at 12 million rand. So in total, it's a similar percentage.
Yes. Yeah.
So I've done that calculation
end.
of the prejudice at the end,
Yeah.
Chair,
Okay.
in total.
Okay. Thank you.
Thank you, Chair. Mr. White, can I please refer you now?
I think we are at one already.
I beg your pardon.
Yes.
Thank you, Chair, if it's a convenient
We'll,
time.
we'll take the lunch adjournment and resume at 2 o'clock. We adjourn.
All rise.